Hello, everyone, and welcome to the Peace Through Planning Sunday School class. I think this is our third class, and we have two classes left. So today we have a special guest. We have a lawyer with us, Ashley Fox from W.G. Alexander and Associates, and she's here to talk about wills and estate planning and things like that for you all. Next week we will have someone from the funeral home here and someone from hospice here sharing the time. So we hope you'll come back for that. But otherwise, I will hand it over to Ashley, and thank you all for being here, and for those online, thank you. If you have questions, just make sure at the end to raise your hand and speak into the microphone so the folks online can hear the questions. And if you have questions online, we have some folks monitoring the chat. So please put your questions into the chat for Ashley.
Hello, can everybody hear me okay? I don't want to put it too close because you always get that pop, pop, pop into the microphone. Okay, hi everybody online. This feels really weird talking to a camera. My name's Ashley Fox. I work for W.G. Alexander Associates in Raleigh. We are a boutique elder law and estate planning firm. We're three attorneys. We're actually up to three attorneys. And we focus our practice on elder law and estate planning. So I have too much to get through. I'm going to try to hit as much as I can, and hopefully I'll leave time for some questions at the end. So let me give you a little overview. This is the one we'll be looking at. Okay, so there's three primary areas that I'm going to talk about, and I debated about how to order these because, to be honest with you, the second and third topics are really what you need to think about at the same time. They are effective before your will. Some estate planning documents are effective. Hopefully none of them are effective, especially your will anytime soon, but it's one of those things that you need to have. So I'm going to hit three main areas today. First, I'm going to talk about just the basics, legal documents. What documents do you need into place in order to prepare for your final days? We'll talk about some finance issues, things about banks and a lot of mistakes that we see made. Just so you know, your will does not control everything, and we see a lot of unanticipated results when people pass away. And then lastly, I'll talk about physical care for elderly, and that's not at your death, that's prior to your death, but we do a lot of Medicaid and estate planning special assistance for facility-based care when people need help, and there are a few programs that I just kind of want to touch on and make you aware of them. Okay, first is legal documents. What documents are there? I'll talk about each one of these in turn, and just FYI, everybody is going to have access to the slides, so don't worry about trying to copy everything down. Sometimes I have people take pictures of the slides, which is totally fine, I don't mind, but I'll make sure that these are available. All right, first and foremost, your last will and testament. We have ancillary documents, powers of attorney, medical releases, and then there's trusts. So let me hit on each of these. Did I? Okay. All right, let me start with the ancillary documents. This is the order we put them in our notebook. Seems a little bit backwards. A general durable power of attorney is you give your agent the authority to conduct financial transactions for you. A power of attorney ceases when somebody dies. We have a lot of people that come in and they're like, I want to get to mom's bank accounts. She passed away, I was power of attorney. And you can't get to someone's bank accounts once they've passed away. That ceases, and there's actually a period of time between when the person dies and when an estate is opened that there's technically nobody that has the authority to access the deceased person's account if it was in the person's individual name. Now, I'll talk about joint accounts in a bit, but that's a little bit different. If you have assets that were in the name of the deceased, between date of death and date the estate is open, nobody's allowed to touch it. And that doesn't mean that they don't, but not supposed to. One thing that I always get asked, or when someone does a power of attorney, is my daughter's power of attorney and she's bossing me around. She's telling me what I don't want to do. No, as long as the principal, the person who gave the power of attorney, is competent, what they say goes. So if you're operating under a power of attorney as an agent, You don't have the right to override what mom or dad want. Now, that can create a lot of conflict, and what I see a lot of times are son and daughter know that mom or dad are making some mistakes. Maybe they're being taken advantage of somebody, and that's a really unfortunate area that we see. And I tell people, you can't stop someone from making bad decisions. You can only stop someone from making decisions that they're incapable of making. So if the person has been adjudicated incompetent, or your doctor's notes have determined someone to be incompetent, then at that point, your agency could have a little bit more authority. But in general, the person who granted the power of attorney is always in charge. A springing power of attorney. This is the type of attorney that's only valid when the person becomes incapacitated. We do not like these because when mom or dad has become incapacitated, it's really hard. You have things you need to do right away. They're in the nursing home, they need Medicaid, you need to do some deeds and planning and rearranging assets, and you can't do it until you get notes from the doctor. So we don't generally recommend those. It's burdensome. And I also think that if you have someone who you trust enough to name as your agent under power of attorney, then you should know that they'll abide by it, versus restricting them to only be able to use it in the event you're incapacitated. And the general durable means that it survives your incapacity. It stays valid. The last thing is, we do a lot of Medicaid planning, which requires pretty substantial asset manipulation, deeds and gifting of deeds, and there's a lot of heavy lifting. Most of the powers of attorney that we see come into our office that were done by general practitioners or something that you downloaded from LegalZoom usually don't have enough authority to do what we need to do for our planning in them. So when we have somebody who comes in and mom or dad are still competent, usually my advice is get our power of attorney in place and then let's see how things go. Because people think when mom or dad are going to the nursing home, you got to give everything away, and that's not the case. There are a lot of things you can do, which we'll talk about in a bit. Your healthcare power of attorney is pretty straightforward. Allows your agent to make decisions, healthcare decisions for you in the event that you're incapable of making them. Now again, if you are capable of making them, you make the decisions, not your agent. Advance directive for natural death. That is what's more commonly known as your living will, which means that what do I want to have happen upon my final days? Do I want life-prolonging measures? And you can specify all kinds of things. You can say, I do want this, I don't want this. Generally, what ours does is we say, do what my healthcare agent tells you to do. Usually your family knows what your decisions would make. Now, some people believe that, you know what, I named my daughter as my healthcare agent, but I know she just couldn't bring herself to withhold, nutrition or oxygen, whatever. Then you can specify in there, and your doctor is required to follow that, your written wishes. Because some people's children just can't do it. And if you know that about your family, then it's a good idea to have specific items written down. An advance directive is not a DNR, a do not resuscitate. A do not resuscitate is a medical order, and that's what your doctor puts together. And usually it's going to be on a big yellow piece of paper and stuck to the clipboard at the foot of the bed or somewhere prominent so that it can be seen. Because if something happened and you've got paramedics there and the person's coding, then they need to know, because in general, once CPR is started, they can't just stop it. So you need to make sure that they know whether to even start it. Medical release is a HIPAA waiver. This was a Privacy Act, and this is frustrating because doctors are very, 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 very tight about privacy issues. But you just name whoever you would like to be able to communicate with your doctors. Most doctors' offices have these. When you go in there and you sign your paperwork, it'll say write down who you want to be able to talk to us. So if they have that in place, then that's fine. This is not necessary, but we have it just because it makes sense to have it. The other thing I wanted to point out is with regard to doctors and healthcare, When your child goes to college, legally, as far as healthcare disclosure, your 18 or older year old is a legal stranger from you. So I actually have a friend who, her son went to the college pharmacy, to the doctor, and was requesting Adderall, I think is what it was called. It was some kind of thing that peps them up to study for exams. And that's something that she wanted to know. So in my opinion, at least I know this is what I'm gonna do when my kids get to be, that you want me to pay for your college, you give me a HIPAA release so that you can, find out what's going on with your child, because that kind of thing, you don't want them to go down the wrong road. You want to be able to stop it up front. I keep thinking the machine's that way. Okay, your last will and testament. This is, who do I want to get my stuff? Who do I want to be in charge of my estate? You can nominate an executor in your will. My recommendation would be to at least nominate an alternate. You can nominate a guardian for your minor children, specify what happens to your property upon your death. I recommend that you consider revisiting it every so many years. We have people that come into our office that did their will 15 years ago, and it still does what they want it to do. And I just tell people, that's fine. Everything to my spouse if he survives me, if not, then to my children. That's fine. That's still what you want it to do? Fine. But do get our general power of attorney. Be careful about doing it yourself or, handwritten wills. I've seen too many instances where people's testamentary intent was defeated because, a will wasn't self-proven and we can't find the witnesses. There are all kind of bad things that can go on. In my opinion, well, obviously I have a vested interest, but in my opinion, it's worth a little bit of money to have a professional do that. And the execution requirements vary from state to state as well. The other thing is that if you don't have a will in place, you have inadvertent happenings. For example, we have a lot of families, they're blended families, and they want to treat stepchildren as their children. And North Carolina has a law of intestate succession. This is what happens to your property when you die if you don't have a will. And it does things like not everything goes to your spouse. A portion of it would go to parents or siblings, or it just depends on who is still living in your family as far as where things go. I've had clients that the people were in a second marriage and the house was only in the deceased spouse's name. They didn't have a will. Well, now half of the house belongs to an estranged child from a first marriage, and that's disastrous. Okay, let me talk a little bit about trust. There are a lot of different kinds of trust, and it would be way beyond the scope of our discussion for me to talk about too much. The most common trust that we see these days are a revocable living trust. This is a trust that you execute during your lifetime. You remain the trustee during your capacity. It's treated as if it's yours. Any income goes on your tax returns. You use your own social as the tax ID number for the trust. It's all yours. And then the other negative thing we see a lot are people that don't fund their trust. So you come in, you pay a lot of money to an attorney, you have a trust, and then you have a handful of bank accounts or securities accounts that you didn't fund into the trust. The trust is like a bucket. It sets the rules. And then your assets are stuff you need to put into the bucket. So you want to, like if you have a stock account at Edward Jones, you want to retitle it, John Doe is trustee of the John Doe Revocable Trust. And it, did that? Oh, there it goes. Okay. So what are the advantages of having a revocable living trust? Well, it eases administration. Anything that's in your trust doesn't get caught up in probate. Now, probate is kind of a four-letter word to people these days. It's not really that bad. It just kind of delays things. There's a probate fee that pays the clerk. It's not that bad, really. In North Carolina, it's 0.4%. But why go through that when you don't have to? There are a lot of ways to avoid probate, and doing a trust is one of them. That said, what you pay an attorney to draft your trust may end up being more than your estate would pay in probate fees. But that's not the only factor to consider whether you're interested in initiating a trust. For example, it's easier to administer. Upon your incapacity, upon your death, then your successor trustee steps into your shoes and then conducts the trust business according to the trust. The trust is basically a set of rules. This is what I want for myself, for my property, and it's the trustee's job to follow those rules. It's private. If you have a revocable living trust, your will just basically say, see my trust. The will goes on with the clerk, your trust stays with you. So if you have, for example, if you have one child that's not getting as much as the others, then that you can keep that private. Also from strangers, because anything that's in the estate file in the county is public. Anybody can log on and look at your will, download your will. For example, this is kind of an extreme example, but if your will says, I leave my 4-carat Harry Winston to my daughter Jane Doe, well, guess what? The application has Jane Doe's name and address there. And if somebody knows that she just inherited a 4-carat Harry Winston, then you may have someone who could target her. I'm not trying to scare anybody. It's just that anything in your will is going to be public. All right, I talked about that. Let's see. Okay, let me move on to what I consider to be just as important, in my opinion, to your will, because the will is pretty straightforward. Here are my documents. Definitely, it's a good idea to have them, but there are other aspects of your financial and legal situation that could affect your testamentary intent. Okay, for example, beneficiary designations. A lot of assets don't pass according to your will, they pass according to beneficiary designation. Barbara, can you kind of flag me when I'm getting, like I need to be done, maybe about 5-10 minutes? Okay, sorry, I tend to ramble, so I'm to pull myself back. A lot of assets are not controlled by your will. If your will says, I leave my 401k to my daughter, if your 401k custodian has your son as the beneficiary of that plan, it's going to your son. Not only that, but if you get married and you set your spouse as the beneficiary of your IRA, and then you're divorced 6 months later, then the next year you remarry and you're married to this person for 50 years and you've got kids and grandkids. When you die, that 401k is going to your ex-spouse if you didn't change it. It's not revoked by a divorce. Anything in your will does get revoked by a divorce, but your beneficiary designations don't. And I've seen some pretty bad things happen. The other thing is if you yes?
Can you make your trust the beneficiary of any of those?
Yes. The question is, can you make your trust the beneficiary? Yes, absolutely, and we recommend that quite often. Now, this may be beyond the scope of our discussion, but there could be tax issues with retirement funds and so forth and so on, but yes, we see a lot of instances. For example, if you do not have a beneficiary specified, then it's going to do one of two things. It's either going to go to your estate, which is going to initiate probate fees, or your plan may dictate who the beneficiaries are. Okay, Edward Jones, you have an IRA. If you don't have a beneficiary, it's going to pay your spouse, your children, your parents, your siblings, and that may not be your intent. But yes, we do. And actually, we do a lot of, in asset protection, we actually have a will that creates a testamentary trust, and we provide that trust as the beneficiary quite often. Okay, another problem that I see very often are joint accounts. Be very careful. If you go into the bank and you tell the person at the bank, I want to add my daughter to my account so she can pay bills for me, what they're probably going to do is add this daughter as a joint owner with right of survivorship, which means upon your death, that one daughter gets the whole account. Now, if you want everything to go to the daughter, if she's an only child, fine, that may be what you want. But if you have multiple children, even if your will says, I want everything divided between my 5 kids, if this one daughter is a joint with survivorship on your account, it's all going to that daughter. And I've seen some pretty bad stuff. Now, if all of those siblings get along well, and we have this happen a lot, because joint accounts keep right on going. They don't shut down for probate. You can still access the money as soon as the person dies. So we have a lot of clients who specify a child as a joint owner. That child uses the money, pays the bills, And then when she's done, they divvy it up between all the children. And that's fine too. It's just, know your family and know your intent and make sure your family knows your intent. A possible better solution would be to specify this daughter as a power of attorney on your account. Now that said, once you die, it's going to be locked up until your estate's open. So if your intent is for daughter to still have access to that, then a joint account with survivorship may be an option. There's also joint without survivorship, which just means half goes to the survivor and half goes to your estate. That's pretty rare though. Most banks will default to joint with survivorship when you just say, I want to add her to my account. Just so you know, the DMV is the opposite. When you have a jointly owned car, their default is joint without survivorship. So first spouse dies, second spouse keeps paying the registration, and 8 years later, second spouse dies, children bring the car title to me, and now we have to go back and open 2 estates because we don't have anything to give us permission for the first spouse to die, get the title rearranged. You can put a joint survivorship. If you look on your title, up next to the owner's names, it'll say JTWROS, Joint Tenants with Right of Survivorship. If that's there, then all you need is a death certificate at the DMV to put it in the surviving spouse's name. If it's not, hopefully you'll find this out within a year of when the first spouse dies, because there's a spousal years allowance, which means that a surviving spouse can claim some assets of the deceased spouse. And that's beyond our scope, but if you want to talk to me about it later, we can. It's just an easy way to get some money that was in the deceased spouse's name to the surviving spouse. Okay, you can specify a pay on death or a transfer on death, POD/TOD, on your account. You can go to Wells Fargo, put a pay on death onto your savings account, your checking account. That supersedes what your will says. Now, if I have a family who has 2 children, the children are all mature, great, no problem, then that's fine. Put a pay on death. It does not go through probate. All you need is a death certificate, and they'll just pay the account to the beneficiaries on the account. Okay, let me touch on a little bit. This is our third topic. Talk about care for one's person during their lifetime. There are different levels of needs that people have. You can have in-home care, have people come in and stay with you, family taking care of you. Independent living. This is a facility where each facility will be licensed according to their level of care. You'll have an assisted living facility, skilled nursing, independent. One of the ones that we deal with a lot, we used to do our seminars there until COVID, was Independence Village off Old Raleigh back there behind the Durley and Edwards Mill. But they're independent living. And you can, it's like living in an apartment, basically, and you can pay for any additional care that you need. Usually they provide someone to come help you if you need it. Assisted living. Assisted living is you need help with activities of daily living, and I'll talk about the difference in just a second. The programs that are available, assisted living it's a little bit of a no man's land. When people need assisted living and they run out of money, if you make too much for one program or you have too much for another, then you're out of luck. I can't tell you how many people we've come into our office, mom's out of money, she's in assisted living, and she can't qualify for any program. People think that if I run out of money, the government will take care of me. That's not true. The facilities will kick you out, and the family is left to take care. It's very sad. I always say it's a call your congressman situation, because I feel helpless. Lastly is a nursing facility. So Medicaid is a program that's available to help people pay for nursing. Medicaid does not pay for assisted living. I'll talk about that in a little bit of details in a second. Okay, what does it mean? Assisted living is you need help with some activities of daily living. Toileting, ambulating, getting in and out of bed, dressing, cleaning, those type of things. Nursing means that you need some medical care. For example, if somebody's, catheters, colostomy bags, or I can't pronounce it. open wounds. It's a medical need. If someone is essentially bedbound, that person could qualify for nursing. And this is a doctor decision. The doctor is who makes the recommendation. And we actually have to have a doctor sign off on this is where you need, especially for Medicaid. There's a part of the application process that, okay, this person really needs nursing care. All right, here are 2 programs, and these are about the only 2 programs that are available to help pay for assisted living. Special assistance is a state program. The facilities will call it Medicaid. It's not Medicaid, it's special assistance. Unfortunately, the income cap is very, very low. If your gross income, that means not what goes into your account, but is, your Social Security is more than about $1,200, you make too much. And for memory care, most memory care facilities are at the assisted living facility level. But the income cap for memory care units is about $1,500. But if you make a nickel over, you're not going to be eligible. And if you have a spouse who's on assisted living and then their spouse dies and you start getting your spouse's Social Security and it goes up, you could lose the benefit. It's very hard to qualify for that. Usually it's a stay-home mom whose Social Security is $800 a month, and as long as she's still alive. I mean, as long as the husband's still alive. The other problem is getting facilities to accept it. Most facilities in Wake County don't take it because they don't really need to. They make more money on a private pay. The other program available to help pay for assisted living is a VA pension. I won't get into too much details. I'll just let you know that it's there. There are income asset rules, and I can talk about that offline. But it's only available for war period veterans and their spouses, surviving spouses. If you're divorced, you can't get it. So widows, widowers of war period veterans. And the VA has war period dates on there. The amount of the benefit, it's just it's based on your income, and there are things we can do to kind of get your income down so that your benefit will be maximum. It varies depending on whether they're dependents, whether the sick person is the spouse or the actual veteran, but usually it varies about $1,000 to $2,500 per month. But it won't pay for your entire assisted living, but it helps. What can you get to help you pay for nursing level of care? Anyone who is a retired veteran, meaning 20 plus years, you'll know if you are, you'll know if you're on Tricare. Tricare has a fantastic skilled nursing benefit. Hospitals don't know it, nursing homes don't know it. Talk to me if that applies. That'd be way off topic for this discussion. Medicare pays for some of your nursing. Actually, if you're in the hospital, then you go to rehab. It'll pay for part of that. It pays for the first 20 days in full, then 21 through up to 100. Very few people make it to 100 because Medicare kicks them off. They'll kick you off as quickly as they possibly can. The rules are you have to be continuing to improve. But there's also an aspect of if you can show that the person would regress if they are discharged from Medicare, then you might be able to stay longer. And usually they're pretty cooperative with 1 or 2 appeals. You can appeal it, but you got to do it quickly. If at that point the person needs nursing care, then that's the time to consider Medicaid. So Medicaid is a federal program. It's administered by the states. It's for the medically needy. And in general, the way it works is your income goes to the facility, and Medicaid pays the rest. And you get a $30 monthly needs allowance. Woo-hoo. Don't spend it all in one place. So it can be possible for even middle-class persons. I hear all the common myths that we see. I can't qualify until I run out of money. That's not true. There are things that can be done. The state's going to take my home. Maybe, maybe not. If you protect it, now, we get a lot of calls. My grandmother died 3 months ago. She was on Medicaid. What do we do? Once the recipients passed away, it is what it is. I'll talk about it in just a minute because Medicaid wants their money back. And then a lot of the nursing homes will tell you, well, just private pay us until you're out of money and then we'll get you on Medicaid. Well, you don't have to do that. There are things that you can do to protect assets. So what I'm going to talk about is eligibility, how can I be eligible, and then asset protection, protecting from estate recovery. So how do you qualify? The rules are over 65, blind or disabled, and you need nursing level of care. The income is, your income has to be less than the cost of care. So even if you make $4,000 a month, then your $4,000 goes to the facility and Medicaid pays the rest. Your assets, this is our sandbox, so to speak. You have to have less than $2,000 of countable assets. Now, countable does a lot of work in that sentence, and I'll talk a little bit about that. Medicaid also has a 5-year look back, so you can't give everything away and then apply. They will actually delay paying for you based on how much you gave away. And again, as I discussed, there are 2 aspects to Medicaid. There's number 1, can I qualify? And then there's number 2, what can I do to protect, those non-countable assets we had up there? What can I do to protect those, to prevent my executor from having to pay all the money to Medicaid when I die? Okay, so what's countable? Well, basically anything that's not countable is countable. Sounds it's easier to specify what is not countable. Your primary home with the intent to return home. Now you're thinking, Mom's never gonna return home, she's gonna live in a nursing home forever. For goodness sakes, whatever you do, if anybody at Medicaid ever asks you, does this person intend to return home, your answer is yes. Yes, yes, yes. If you say no, that house just became a countable asset, and you're in a really bad way. There are other assets that are not countable. For example, one vehicle of any bathroom. We actually had a client one time that they had a motor coach because Mom needed a rolling bathroom, and one vehicle of any value. Now remember, after your death, that Ferrari that you had that was not countable, well, Medicaid is going to want you to sell that Ferrari and pay them the money for estate recovery. You can have up to $10,000 face value of life insurance. A prepaid funeral, that's a good spend down. Prepay your funeral, it has to be paid anyway. And it has to be an irrevocable funeral contract. Sometimes government bonds can be non-countable, and I'm not going to go deep into that right now. Jointly owned real estate is not countable, which is kind of where we work our magic. Now remember, if you jointly own real estate, whatever portion you own is potentially vulnerable to estate recovery, but we use real estate to spend down large amounts of money, if we can. I'm not going to get into the rules about, we have people buy a percentage of their child's house or go in together to buy a rental property, make it joint, it's not countable. You just have to remember to protect it from estate recovery. All of your household items, your clothes, your furniture, your jewelry, anything that doesn't, have a registration is not countable. So countable is, your stock accounts, your bank accounts. In North Carolina, IRAs are countable. About 5. Okay, IRAs are countable. Now, okay, all right. So I'll aim for 7.5. So, okay, so I'll cut it off about 10:33. Sorry, I'm really bad at managing time. Personal property, not countable. Let me get where I'm going. Okay, when you're married, a spouse is on Medicaid, the spouse at home is allowed to keep more money than the spouse in the facility. So facility spouse, $2,000 or less. Spouse at home, it's called a community spouse resource allowance. And it ranges, and it depends on how much assets you as a couple have together. I won't get into the rules, but so in that regard, people make a mistake a lot of spending down before a spouse is in the facility. If you spend down too much, then the at-home spouse's allowance will be less because they have less as a married couple. So don't spend down, in my opinion, without asking for help. Okay, talking about married persons. If you have wife in the facility on Medicaid, husband's at home, he's got $100,000, his community spouse allowance he was allowed to keep. What's going to happen if husband has a heart attack and dies? If he doesn't have a will, that $100,000 is going to his wife who's on a Medicaid in the facility. Or if he has the house, their jointly owned house, okay, it's fine, she can own it. But what happens is if the spouse at home dies and you have a sweetheart will, everything to my spouse, then that house is going to go to the spouse in the facility. She can still be eligible, but then what's going to happen is upon her death, estate recovery is going to get it. They don't file for estate recovery if there's a surviving spouse or a disabled child. They say they defer it, and we are still trying to figure out what in the world they mean with regard to defer. Are you going to wait until the spouse dies 15 years later and they've moved 4 times? That's we're still dealing with that. But what we do is we actually have a will. The spouse at home will set up a will with a trust. When I die, everything goes to this trust over here. It can be used for my wife who's on Medicaid, but it's not hers. It's not a countable asset. We call it an S&T will, a supplemental needs trust will. Then, upon the spouse who's in the facility's death, it goes to the children. It's fantastic. It works wonderfully. And you know how we were talking earlier about the beneficiary designations? If husband at home, for example, has a life insurance policy, make sure that he's changed his beneficiary to that trust, not still wife. Because chances are, whatever life insurance, IRA you have, chances are you named your spouse as the beneficiary. So if your spouse goes on Medicaid, for goodness sakes, make sure you change it. Name it to your children. Name it to the trust under your will. Just don't let it, because if it goes to the wife, boom, she's going to get kicked off Medicaid. Okay, I talked about this a little bit. All right, I think I talked about that. Okay, one thing to consider is please think ahead. One thing I wanted to mention is, oh, the state's going to get my home. I'm going to just go ahead and give my home to my kids now. Be careful. There can be really bad tax consequences when you do that. When you give away property, I'm not going to get too deep into it. There are potential really bad tax consequences with doing that, which could cost your kids a lot of money when the time comes that they sell it. So, and also spend down. Don't spend down too early. You want your married couple amount to be as much as possible so the spouse at home is able to keep as much as possible. Okay, I think we're 10:31. All right, last and not least, I will give my shameless business plug. If you'd like to talk about any further, I'll stay here as long as you want me. Also, whenever we do a presentation, we will give a free initial consult to anybody who wants to come, so you can just call the office and you can talk to me or Thomas or Bill, anybody you want to. It's not going to hurt my feelings in the least. You know, Bill's been in practice for like 40 years. He tends to be about 2 or 3 months out to book him. If you want to come talk to Bill, great. I'm be happy to have anybody come see us. There's our phone number, and all you got to do is tell them that you attended a seminar, and our initial consult, which is usually $395, will be waived. And if you after that talk you don't need anything, then great. Have a wonderful week. Come back and see us when you do. But chances are, my advice at that time is going to be get our power of attorney. It's extraordinarily helpful. It gives you the tools that you need to be able to plan. I also was going to mention one thing real quick. There are Medicaid Asset Protection Trusts, 5-year trust. I wanted to mention it because a lot of people hear about it. You can take a lot of assets, put them into this trust. If they sit there for 5 years, an irrevocable trust, then they're not going to be countable. But the issue is that how do you know whether you're going to live another 5 years, or you lose control over it? We do them. There are some elder law attorneys that do them a lot, but it's a possibility, just let you know it's out there, to deal with the 5-year look back. But there are a lot of things that we can do on a crisis basis, meaning most of our clients come to us, mom is on rehab now, she's got to go to nursing indefinitely. what do we do now? And there really is a lot of things that you can do to protect, to help mom get eligible, and also to protect her assets for her loved ones. So I guess I'll cut it off there. Let me see, I keep pointing at the screen. There we go. Okay, I won't put the remote in the water. Oh. So I'll open it up if anybody has any questions. I can keep talking. Yes, sir.
So we heard a lot about personal assets. I also have an LLC that's starting to gather assets. How do we handle business?
The question is, how do we consider LLC? An LLC is technically personal property that belongs to you if you're the manager owner of the LLC. Most people use LLCs as pass-throughs, it provides a little bit of protection, but with regard to assets, anything that's in the LLC is going to be a countable asset. If it would be a countable asset if it was in your hands. The value of the LLC is personal property.
So, like we have a house, and so when you add a kid to your deed before, when do you do that?
Okay, the question is, you have a primary home, your primary residence, when do you do that? You can, we have what we call a legacy deed. It's probably more commonly known as a ladybird deed. It creates an enhanced life estate, meaning that this is my house for my life, and then when I die, it's going to go to whomever I name as the remainder in my will. So my recommendation is not to burden your real estate any earlier than you have to. Now, the legacy deed, you do retain all ownership control during your lifetime. But that said, they can be expensive. We charge around $1,000 for a legacy deed. If we are doing Medicaid planning for somebody, with our fee, it includes any documents we need, any deeds, if the person is still competent, we do wills, powers of attorney. But my suggestion, and I'm probably beating a dead horse with this, is just to make sure that you have a good power of attorney in place. Because you really don't have to worry about estate recovery until you have actually been on Medicaid. There's nothing to recover if you haven't been qualified for Medicaid. And Medicaid does not pursue estate recovery if, number one, your estate is less than $5,000, they defer, or if Medicaid has paid less than $3,000 for you. So that gives you about a half a month, basically, on Medicaid before estate recovery becomes an issue. You could do a legacy deed, if you've been in the nursing home on Medicaid for a year. It just has to be done before the person passes away. So normally what I recommend to people is, don't spend the money to execute a legacy deed until you know you're going to need it. And in that case, if you have a good power of attorney in place, I have, in years, I think I have seen 2 powers of attorney that people who have brought into our office that were sufficient to do the legacy deed. Legacy deed is considered a gift of real estate. Most powers of attorney limit gifting to your historical pattern of gifting. Most powers of attorney restrict gifting. They'll say the agent cannot gift anything to themselves, or if they don't specifically say unlimited gifting of real estate. If it doesn't say real estate, then it means not real. Even if you say any and all of my property, no, it has to say real estate. So I've only seen probably 2, and actually one of those was from another attorney's office who Bill is of counsel for. So she actually had our power of attorney because she got it from us. There are probably, try not to knock that thing over. There are probably less than 10 attorneys that I know of in the state who I would really trust to do advanced Medicaid planning. And I know of a couple in the mountains, a couple at the beach, but my recommendation would be not to do anything with your real estate until you need to. Yes? I'm not really sure of all the details of who wins the battle between Medicare and Tricare. I'm not intimately familiar with Tricare, but what I will say about Medicare will kick you out as quickly as they possibly can. And what happens is Tricare has an unlimited lifetime skilled nursing benefit. The facilities, I've had so many people come back to me and say, no, I asked, the facility said, no, it doesn't, no, it doesn't. I'm like, it does, it does, it does. Take your invoice and send it to Tricare. They will pay it. However, if you fail to invoice Tricare even once, then you have to restart. It has to start with a 3-night qualifying stay in the hospital, same as Medicare. You have to have a 3-night qualifying stay in the hospital. Be careful that you're admitted. We've had some people who were on observation, and then they get to rehab and find out that Medicare's not paying. Even though they were, I think Bill had one that the person was in the hospital for 2 weeks, but they were officially categorized as observation. So 3-night qualifying admission in the hospital and then discharged to rehab. But the problem is that once Medicare stops paying, your supplemental insurance will stop paying. And the facilities and the hospitals and everybody assumes that Tricare is going to stop paying because everybody stops paying when Medicare stops paying. And you really have to be an advocate and beating on the door of the facility and telling them, send the invoice to Tricare, send the invoice to Tricare. They'll keep paying it. But if they don't get the invoice, then it's done. You can't go back and, oh, we missed a month, can you start us back up? No. But as far as the overlap between, you've got Medicare, you've got Tricare, who's going to pay, I'm really not sure. I would ask, the Tricare people. My guess is it would be however you normally file your insurance when you have like a hospital stay. Is it Medicare, is it Tricare? I'm not really sure. I'll check on that. My mother-in-law has got Tricare, so I'll ask her who pays for her. I think she's actually going in to have a kidney stone broken up today. Okay. I'm gonna draw a line on the floor here. I'm gonna put my drink. I'm not gonna back up behind the drink. There, okay. Yes? Do you mean that you're... Yes. Yeah, actually, let me ask, because I need a little bit of clarification. The question was, we have IRAs in trust, and is that countable? Let me ask you this. So IRAs are going to be in your individual names. If you've made them into a trust, then that would be a distribution. So my guess is that you have your beneficiary as the trust. Is that correct? Anything. Okay, all right, it's one of the, okay. Then, yes, it would be countable if you are the grantor of that trust, correct? Okay, yes. Let me back up a little bit. Is the trust revocable or irrevocable? If you have assets in an irrevocable trust, then once they sit in that trust for 5 years, they're not considered. Medicaid has a 5-year look back. So you can actually put assets into a trust and then wait 5 years. That would depend on whether that trust is revocable or irrevocable. If it's revocable, it would be countable. Yeah, I can't imagine that it would be, that would be a lot of loss of control. Anything that you have access to, as far as accounts, retirement accounts, if you have a very large IRA, retirement accounts, 401ks, honestly, one option may be move to Florida, because Florida does not count IRAs for Medicaid. So you can have a $10 million IRA and it's not countable. I'm not moving to Florida. Actually, Bill actually did have one client who moved to Florida because it was, I'm staying at the cup. I do, I tend to, sorry, I'm a teeterer. Yeah, anything that you can get to that's outside of these are non-countable, the car, life insurance, personal property, an IRA, anything that's revocable is going to be countable. Barbara looks like she's ready to stand up.
We're getting close. We're getting close to that magic hour. And I just want to say thank you to Ashley. She is a walking whatever. She has more knowledge in that head that just makes my head hurt to think about it. But we do say a very sincere thank you to her for coming and sharing her knowledge. And as she said, she is willing to talk. We'll have to go out in that narthex to talk because they're going to get ready for worship. But she is willing to talk to us. And we do say thank you. Dawn?
I think there's the question is, how do we get the slideshow? I think that there's a Google Drive. Mark said there was. Yeah. Okay.
Look at the YouTube recording, and it's in the notes.
All right, thank you. And if anyone doesn't have a Microsoft Office package, Mark, is that saved as a PowerPoint? A PDF. Okay, yeah. Okay, good, yeah. Well, thank you guys for having me. Yes. Yeah.